Title 6 Paternity and Filiation, Chapter 1 Legitimate Children, 163. The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. 164. Children conceived or born during the marriage of the parents are legitimate. Children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. 165. Children conceived and born outside a valid marriage are illegitimate unless otherwise provided in this code. 166. Legitimacy of a child may be impugned only on the following grounds. 1. That it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of a. The physical incapacity of the husband to have sexual intercourse with his wife; 2. The fact that the husband and wife were living separately in such a way that sexual intercourse was not possible; or c. Serious illness of the husband which absolutely prevented sexual intercourse. 2. That it is proved that for biological or other scientific reasons the child could not have been that of the husband, except in the instance provided in the second paragraph of Article 164, or 3. That in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. 167. The child shall be considered legitimate although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. 169. The legitimacy or illegitimacy of a child before born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. 170. The action to impugn the legitimacy of the child should be brought within 1 year from the knowledge of the birth or its recording in the civil register if the husband or, in a proper case, any of his heirs should reside in the city or municipality where the birth took place or was recorded. If the husband or, in his default, all of his heirs do not reside at the place of birth as defined in the first paragraph or where it was recorded, the period shall be 2 years if they should reside in the Philippines and 3 years if abroad. If the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or of the fact of registration of said birth, whichever is earlier. 171. The heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint without having desisted therefrom. Or 3. If the child was born after the death of the husband. Chapter 2. Proof of Filiation. 172. The filiation of legitimate children is established by any of the following: 1. The record of birth appearing in the civil register or a final judgment; or 2. An admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open and continuous possession of the status of a legitimate child; or 2. Any other means allowed by the rules of court and special laws. 173. The action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. The action already commenced by the child shall survive, notwithstanding the death of either or both of the parties. 174. Legitimate children shall have the right: 1. To bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames; 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters in conformity with the provisions of this code on support; and 3. To be entitled to the legitim and other successional rights granted to them by the Civil Code. Chapter 3. Illegitimate Children. 175. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173, except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. 176. Legitimate children shall use the surname and shall be under the parental authority of their mother and shall be entitled to support in conformity with this code. However, illegitimate children may use the surname of their father if their filiation has been expressly recognized by their father through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father, provided the father has the right to institute an action before the regular courts to prove non-filiation during his lifetime. The legitim of each illegitimate child shall consist of one half of the legitim of a legitimate child. Chapter 4. Legitimated Children. 177. Children conceived and born outside of wedlock of parents who, at the time of conception of the former, were not disqualified by any impediment to marry each other, or were so disqualified only because either or both of them were below 18 years of age, may be legitimated. 178. Legitimation shall take place by a subsequent valid marriage between parents. The annulment of a voidable marriage shall not affect the legitimation. 179. Legitimated children shall enjoy the same rights as legitimate children. 180. The effects of legitimation shall retroact to the time of the child's birth. 181. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. 182. Legitimation may be impugned only by those who are prejudiced in their rights within 5 years from the time their cause of action accrues.